Black, in his concurring opinion, emphasizes the need to protect the press against suits by public officials and so on. So there's a lot of protection in it for the press. But it seems to me that the central theme of the decision about the central meaning of the First Amendment, the right that all of us have under the Madisonian premise to criticize government, is a right belonging to all Americans, not to the press. And the court did not, in deciding the case, say, we rely on those last 4 words in the First Amendment or of the press to decide this case, as the court has never done, relied on the press clause as the basis for deciding a particular decision. Well, what might the court have done other than invent this actual malice or constitutional fault rule to relieve the New York Times and the northern media from the pressure from libel suits, putting them out of business in the South? As I say, the court's logic, Justice Brennan's logic, did not lead inexorably to the actual malice rule as a remedy. And 3 justices, Black, joined by Douglas and Goldberg, well, here's a summary of the Sullivan rule, have to prove a false statement made with actual malice, and that means knowing it was false or with reckless disregard for truth or falsity, extending the rules of Butts and Walker in the public figure cases. And then you got Hugo Black, who comes out and says, this is an evanescent protection for freedom of speech in the press, this actual malice rule. There's no reason to think that this jury in the Sullivan case would have come out any differently if they had been instructed to find actual malice. They would have found it. The state of mind requirement is not a genuine protection for free speech. And I might add, it also is somewhat dangerous, at least to the press, because if the plaintiff has to prove that you knew it was false or that you acted recklessly with regard to truth or falsity, that basically invites the plaintiff's lawyer into your newsroom to rummage around, to go through the files, to see all of the documents about your story, all the drafts of your story, all the notes that you've taken of various sources and so on, and to take the depositions, the testimony under oath, of everybody having anything to do with the story, the reporter, the editor, all of the sources. And that expensive and excruciating process can be justified by libel plaintiffs because the burden's on them to prove both falsity and actual malice or constitutional fault. So this rule has some consequences which are not altogether favorable to the press. And Black, Douglas, and Goldberg in a separate concurring opinion, also joined by Douglas, say we should take the extra step. We should have let that other shoe drop. We can happily live in this country with no libel suits by public officials with regard to criticism of their official conduct. That, of course, would allow public officials to sue for libel about their private conduct. But the court wouldn't go there. And it's always been somewhat puzzling why the court didn't, why Justice Brennan stopped short of saying no libel suits by public officials about their official conduct. He gave a speech that became a law review article a year or so after Sullivan in which he dropped some hints about that. And it appears that he and a majority of the justices on the court didn't want to get to a place where somebody could deliberately lie about a public official and be protected. The court was not willing to countenance deliberate lies as protected by the First Amendment, at least deliberate lies about an individual. Thursday, we see the Alvarez case involving a deliberate lie, which turns out to be protected, but that wasn't about any individual. And Goldberg, in his concurring opinion, takes the court's point about we've never countenanced libel on government, seditious libel, and he says the court was right to say that you can't libel government, but on the other concerning point, it's also right that criticism of the government agency, criticism of government, is criticism of the government official, and that's just like libel on government, and the court should have said so that the court would have abolished libel suits against government officials about their official conduct altogether. And that view only commanded the 3 concurring opinions and not the majority of justices, so that has never prevailed. Since Sullivan, the court has toyed with the idea of altering the Sullivan rule so that the question would be whether the statement is of public concern, rather than looking to who the plaintiff is to see whether they have to prove actual malice. Look at the statement itself, and if it's of public concern, that triggers the enhanced proof that the plaintiff has to make. The court toyed with that in a case or two and then abandoned it and went back to, yep, it's the status of the plaintiff that determines what they have to prove. Another option that the court might have used is simply to limit damages that can be recovered by, say, a public official or a public figure, to limit the damages to their actual out-of-pocket provable damages, no general damages. I mean, if the verdict in the Sullivan case had been for $50 or $500 as a token or something like that, how threatening would that have been to speech about public officials? It wouldn't have been. The problem with that is one of principle. The law would still be imposing liability for criticism, happens to be false, of a public official performing his official duties. So if you can't stomach that principle, then you can't just get away with saying that you can limit it to damages. Since Sullivan, the court has had a few more libel cases of Justice Goldberg. And the most important libel decision since Sullivan was Gertz versus Welch, 10 years later. Gertz was Elmer Gertz, who was a prominent Chicago lawyer who did a lot of civil rights work. And he had been on a mayor's commission on something or other in the city of Chicago, had once held public office, but he was, at the time of the case, a private lawyer. And he had represented the family of Black Panther in Chicago who had been killed by the police. And he brought a wrongful death suit against the police in Chicago. Robert Welch, who was the head of the John Birch Society, a very right-wing, somewhat racist organization that had a newsletter that they put out in which they accused Elmer Gertz of being a communist and bringing a phony case against the cops and so on, libeling him in his profession. Gertz sued, and the case went to trial, and it's all a very complicated scenario procedurally, but the case went to the Supreme Court, which had to decide a couple of issues about implementing the Sullivan rule. One is, what's a private figure have to prove? Somebody who's not a public figure and somebody who's not a public official. And the court determined that Gertz was not a public official, he wasn't, and was not a public figure. The court undertook to define categories of people who could be considered public figures and have to prove constitutional fault. And they had three. One is an all-purpose or pervasive public figure, you know, a household name, somebody who's totally famous, Bill Clinton, somebody like that. Hillary Clinton's no longer a public official either. All-purpose public figures or limited-purpose public figures, also called vortex public figures. And this is somebody who would not ordinarily be considered a public figure, but has injected himself or herself into the vortex of a public issue, a public controversy, has taken a stand publicly on some issue that's being bruited about in the public. Maybe has testified before Congress, or has been interviewed on a television news show, or has written an article or a book. Somebody who has taken a position on a public issue becomes a limited-purpose public figure and has to prove the same thing as an all-purpose public figure and the same thing as any public official, that is, constitutional fault. And then there may be, the court said, a category of involuntary public figures. These are people who get caught up in some public controversy. Maybe they're accused of crime, or they happen to be on the scene when something newsworthy happens, and they get caught up in it. They didn't voluntarily inject themselves into the vortex of anything. They just happen to be there. And the court said, well, maybe there's a category of involuntary public figures, and the subsequent cases in the lower courts bear that out. There are some people who may fall into that category. Well, having defined all of these, the court rejects the idea that Gertz is any one of them. He's not a public figure of any kind, not a public official. He's a private figure. And then the court had to decide, well, what does a private figure have to prove? And the court in Gertz said, libel is no longer a no-fault tort. The states may not, consistently with the First Amendment, impose liability without fault in a libel case. Every libel case requires fault of some sort, and left it up to the states to define the degree of fault that would be required. They could go the whole way and say, well, private figures have the same burden of proof that all the public figures and public officials do. Constitutional fault, knowledge of falsity or reckless disregard for the truth. Some states have gone there. California and most states have not. Rather, they have said that the standard of fault for a private plaintiff is negligence, simply showing that the publisher did not act as a reasonable publisher would in the circumstances. Fell below the standard of care that a reasonable publisher would have exercised, acted negligently. But no more no-fault libel. So, was Sullivan a good thing? When it was decided, Professor Alexander Michaeljohn, who I've mentioned before, was this courageous defender of freedom of speech, his field was the First Amendment, said that the Sullivan case was an occasion for dancing in the streets. I think it's a mixed blessing because of what I mentioned before, that inquiry into recklessness and so on is both intrusive and expensive, and the cost of defending a libel case is significantly higher. And it's legitimate to ask if the law might be clearer and the press freer if the court had simply said that you can't prove libel damages without proof of actual damages. So that's all. Any lingering questions? Who now? No? Man comes up with lots of questions, secretly from you. Okay, then Thursday we'll do the Great Liar case. It's a really terrific case from last June.